Good afternoon. We're here in the matter of Body Lowe's, MD, Dr. Sethi and MD, and Dr. Atasi and Patel versus Medical Specialist, Inc., PC et al., Karen Jordan, MD, and Medical Specialist, PC et al. Are 45 CO1, 1210 PL 102. We're here for our closing arguments and submission of the findings and conclusions.
Yes, sir.
Okay, are we ready to proceed?
We are, Your Honor. My recollection is the last time we were together, you wanted 30 minutes from each side. Is that correct?
That'll be fine.
About 15 minutes to make my initial presentation and then reserve the rest for
all right.
As the court well knows, the standard for the granting of a preliminary injunction is the probability of success on the merits, the existence of irreparable injury, or stated another way, the lack of an adequate legal remedy, the balance of the hardships in favor of the movement, and the public interest is not disturbed by the granting of the motion. In this particular case, the probability of success on the merits is clear. Each of the plaintiffs have violated their restrictive covenants. Each of them, as you recall, have employment contracts with medical specialists. Each of those employment contracts contain restrictive covenants, and each of them have violated those covenants. Those restrictive covenants, as you will recall, are the same in each of the 4 employment agreements and are contained at paragraphs 4.4, 4.5, 4.6, and 4.7. They provide variously that during a period of 2 years after the termination of their employment, they are not to engage in the practice of medicine within 10 miles of any of the facilities at which medical specialists has practiced medicine, or more particularly where they have practiced medicine as employees of medical specialists. They are not to engage in a competing business or have an ownership interest in another business also during that 2-year period and within the 10-mile restrictive covenant. They are not to solicit either medical specialist patients they took care of prior to their departure, or any of the employees, and they are each to resign their hospital privileges during the 2-year period. In this case, each of them have violated one or more of those covenants. All have violated 4.4. They continue to practice medicine. All have violated 4.7. They have failed to resign their privileges. And 3 of the 4 have solicited patients, in several cases, in direct violation of paragraphs 5.3 of their employment agreements, which forbids them from leaving with any patient lists upon their departure from employment. They are to surrender all of them, as you recall, and in this case we know that Drs. Sethi, Patel, and Laos, in fact, utilized the time during which they remained employed by medical specialists after they gave notice of their intent to terminate their contracts to, in part, prepare lists of patients who they were caring for in order to set up their new practice. These all violate the covenants. Now, what's the consequence of all of this? Well, as we know, an injunction is appropriate because of money damages, that is, money damage relief, is not an adequate remedy under these circumstances. A preliminary injunction is appropriate to remedy a breached non-competition agreement, and we're told that by the Supreme Court in 2008 by Central Indiana Podiatry. And we talked the other day about competitive injury. And you'll recall that counsel indicated to you, well, one can compute the number of patients that are seen by the departing physicians, One can figure out what the profit might be with regard to that, and that can serve as an adequate damage award, and therefore the irreparable injury leg of the model for granting preliminary injunction is not satisfied. But the Supreme Court met that same argument head-on in Central Indiana Podiatry in 2008, and here's what they tell you. Damages for some wrongs may be readily quantified. The revenue from patients who moved to Dr. Kruger, who was the podiatrist who left, from the CIP offices, Central Indiana Podiatry, where he worked, may be measured. But the effect of Dr. Kruger's move on new patients is unlikely to be provable and may be substantial. We assume that many patients choose their physicians based upon referrals by other patients and word-of-mouth references from patients. Others use the yellow pages and other resources. As a result, it is virtually impossible to quantify the profits diverted by Kruger's move. And as a result, preliminary injunction was the proper relief to deal with his activities. Now, we also know that there is nothing per se in violation of covenants not to compete among physicians. We know that well from Raimundo back in 1983. We know it again from medical specialists, 2 cases with Dr. Sluian from the early part of the 1990s. And we know again from Central Indiana Podiatry versus Kruger that it is particularly appropriate to make use of preliminary injunction to restrict the use of the resources of the employer. And as we are told again by the Supreme Court in Kruger, we hold that non-competition agreements between a physician and a medical group are not per se void, as against public policy, and enforceable to the extent they are reasonable. To be geographically reasonable, the agreement may restrict only that area in which the physician developed patient relationships using the practice group's resources. And that's the reason for the 2-year, 10-mile measurement that becomes the central part of the covenant. It measures the use of the group's resources to develop a patient network, which is then used by the physician who departs the group and fails to comply with the covenant. That's the reason the covenant is upheld, because the physician has used the group's resources to develop a practice, and the result is to harm the group by his departure and his failure to adhere to the restrictive covenant. And we know this again because when Dr. Sluian tried to make this same argument against his attorneys after he had lost the case against medical specialists, the Court of Appeals told him the covenant prohibition against Dr. Sluian's practicing within a 10-mile radius of each hospital served by specialists, that is, medical specialists, the movement in this case to be reasonable effort to protect the continued success of medical specialists, a legitimate interest worthy of protection. So if the continued success worthy of protection was not something that the Court of Appeals said was improper in Sluian, in fact, it enforced the covenant because it wanted medical specialists to be successful. Why is it in this case that these 4 physicians are arguing that somehow or another they are exempted from these rules? It is impossible for me to distinguish those cases, Kruger and Sluian, from what is before us now, what is indisputably a violation of those covenants. And the critical interest that is to be protected is the interest that the court in Harris versus Primus in 1983 said should be protected. Again, talking about a physician who left the South Bend Clinic. And what happens in that case? The members of the clinic who spent years and money developing the South Bend Clinic had a legitimate and realistic desire to protect not only their investment in Dr. Primus but also to restrict her competition with them once she left the clinic. They have a protectable interest in enforcing the covenant against Dr. Primus. Now, the only thing we're told in opposition to all of this is that medical specialist does not have a legitimate protectable interest. But you'll recall that these plaintiffs themselves insisted that they had to work for medical specialists during the unexpired term of their contracts prior to the termination on June 30th, 2013. What do they say? Quote, however, their willingness to perform has the precondition of it being understood that they are performing for Medical Specialists, Inc., PC, the employer that they signed agreements with. And then again, at the bottom part of that letter, which is Plaintiff's Exhibit number 4, but their willingness to do so is preconditioned on it being understood that they are performing for Medical Specialists, Inc., PC. So the very people in this case who say you don't have a protectable interest because you're not an ongoing entity are the very people who demanded that their contracts be enforced and that they be paid in accordance with their contracts with medical specialists. And specifically, it had to be understood that they were medical specialists' employees. Nevertheless, they maintain that they are entitled to repudiate all of their obligations under that contract. They don't have any obligations under paragraph 5.3. They can leave with anything they want, including patient lists to set up their new practice. And they can violate their covenants in paragraphs 4.4, 4.5, 4.6, and 4.7 with impunity. Nevertheless, as we were told by Dr. Patel the other day from the witness stand, Exhibit F to his employment contract requires that as a B unit holder, he is entitled to a redemption of 1/5 the number of his B units over the next 5 years. And what did he say when I asked him if he expected to be paid in accordance with that contract provision? He did. So they were paid because they insisted upon being paid. They were paid because they insisted upon working only for medical specialists. He expects, Dr. Patel expects to be paid as a B unit holder of his interest, but he doesn't feel that he has to comply with any of the terms and conditions of his contract. And, for that matter, neither do the others. Well, what does the law say about their obligations? You are estopped from arguing that no employment exists with medical specialists because you cannot accept the benefits of a contract and then repudiate its obligations. It's well established under Indiana law that a party may not accept benefits under an agreement or instrument and at the same time repudiate its obligations. And we know that, if from no other case, than the Raimundo case, where the Supreme Court told us that Dr. Raimundo accepted the benefits of his employment contract for approximately 2.5 years, and therefore he could not claim the benefits under the contract and also repudiate its obligations. Nevertheless, that's exactly what they want to do. Now, we also know that there was an asset purchase agreement, but that asset purchase agreement did not extinguish medical specialists. Medical specialists remained in existence, if for no other reason, to supervise, pay, and direct the plaintiffs themselves. And medical specialists recognized that they had to hire replacement physicians once these physicians left. Why was that the case? Because they recognized that at non-Franciscan Alliance hospitals, they had to provide individuals who were not employed by Franciscan Alliance in order to serve the various interests of those hospitals. You recall Dr. Stemmer talking about the fact that medical specialists has been Switzerland in the past. That is, there are large unified healthcare groups in the county, primarily the community group and the Franciscan Alliance. And in order to satisfy the needs of the community group, medical specialists has to provide services to the community group with physicians who, when they are doing so, are not Franciscan Alliance employees. The May 22nd, 2013 agreement recognizes that fact. But what is equally important is that after the contract, the asset purchase contract was inked in October of 2012, medical specialists entered into new contracts with hospitals in the community hospital firmament in January and February of 2013. Those contracts were between St. Mary's in Hobart, St. Catherine's in East Chicago, and the community hospital itself. All of those contracts were with medical specialists, and medical specialists has to have the non-Franciscan Alliance employees to provide the service with that. That's the reason for the hiring of Dr. Chi. That's the reason for the letters of intent that have been executed with a number of physicians to replace the departing physicians who work for medical specialists and left at the end of June, and to replace them with other physicians who can provide similar services when they are not Franciscan Alliance employees, but more importantly, to provide service to the community hospital group by individuals who are not otherwise involved. So the last two issues realize the public interest and the balance of the hardships. We know from the Raimundo case that the public interest is served by freedom of contract, and we're going to treat physicians as adults, and that's the overwhelming public interest consideration. And the balance of hardships here tilts in favor of medical specialists, because we know from Harris versus Primus, it's right to protect the investment of time, of labor, during the period of time that the members of medical specialists built that up. And they should not be in a position where that is undermined by people who they brought into the practice, supported, nurtured, and then to have them leave and compete against them. That's the whole point of preliminary injunctions in this case. I'll reserve the rest of my time.
Okay.
Second, I'll get our electronic. Your Honor, I want to be able to paint a picture for the court of this particular case and this particular transaction, instead of looking back many years ago, as much as 25 years ago in some cases, at the Raimundo case and the Sluion case, that have been repeatedly cited to the court as a means by which these restrictive covenants can somehow survive what has happened here. In those cases of Raimundo and Sluion, medical specialists, as we know because we sit here today, and prior to October 1st of 2012, was a very large, ongoing, multi-specialty, multi-physician enterprise, totally independent of hospital or other institutional control. When those doctors departed, Raimundo and Sluion, it was a going enterprise, had not changed its character, had not sold all of its assets. Those doctors simply sought to have their restrictive covenants invalidated, based primarily on the notion that because there is a need for physicians in an underserved area, that they should be allowed to break those covenants, and for no other real reason. This case is totally different for many reasons. The first of which, Your Honor will see on the first slide that we presented, before October 1 of 2012, Medical Specialists Inc. Professional Corporation had approximately 60 professional medical providers. That's doctors, PAs,
nurse practitioners, and so forth. An independent body of shareholders and board of directors, about $60 million in annual revenue from all of its services, and it held numerous assets that I know we went over at length during the trial, some of which are highlighted there. The Scan Infusion Center, Pulmonary Function Labs, Sleep Labs, Laboratories, Physical Therapy Centers, EMR, computers, software systems, furniture, patient lists and files, ultrasound equipment, service marks, software licenses, vehicles, pharmacy supplies, janitorial supplies, contracts, consumables, licenses, governmental authorizations, certificates, prepaid expenses, deposits, and other various medical records. Everything they had, other than their old accounts receivable, which they had earned and were still going to collect because they happened prior to the asset sale. Some key man life insurance policies and a restricted ability to use the name medical specialists outside of a 5-year, 25-mile non-compete radius. That's all. After October 1, the right side of that screen is all they have. They have nothing else. They want to talk about the medical director agreements and that they still have them. And that they always have them. And as Dr. Stemmer sat on the witness stand in front of this court under oath, said, when asked, were those items listed in Schedule 1.1C sold? Were the contracts sold to Franciscan in the asset purchase? Yes. They were assigned. He said, yes, they're there. Yes, they're there. What about Dr. Weaver's contract? Yes, it's listed there in 1.1C. But now they want to unring the bell. And they want to go back and say, well, as of May 22nd, 2013, we better fix this because we don't have anything left that's a protectable interest. They don't have one contract in place with one doctor, as we sit here today, who's working for medical specialists. They have agreements to agree, which, of course, the court knows legally are nothing. That is all they have are agreements to agree with some doctors who have the medical directorship agreements. I want the court to remember that the contract with Dr. Chi isn't even licensed yet in the state of Indiana to even practice here. She's just out of her fellowship. She lives in Maryland. Dr. Chi also, interestingly, was never told that medical specialists that sold all its assets, that medical specialist was not a large multi-specialty practice anymore. Dr. Chi was under the impression they had 10 to 15 infectious disease doctors, which is what she is going to do someday. The medical directorships, even if, assume they existed on October 1st in medical specialists only, which all testimony and records presented in this case, and this record of evidence say they do not, are for contracts for the provision of administrative services. They are not for clinical, hands-on patient care contracts. Medical directorships, medical directors set policy, review employees, set schedules, attend meetings and conferences, direct the way the department's activities are run. They're not clinicians in that sense of the word as a medical director. But in any event, at least until May of 2013, those contracts were bought and paid for by Franciscan. Problem with that transaction is, I think that rather everybody not be aware of that, is that none of those hospitals agreed. That Franciscan, the community hospitals, that's their largest competitor, that Franciscan employed physicians be running departments in their competitor's hospital. They never obtained the consents that they intended to obtain from those hospitals. They just went ahead because it's easier to defeat this lawsuit and transfer them back somehow to medical specialists under the May 22nd agreement. 9 months after they sold them. So how did medical specialists and Franciscan intend to deal with the non-consenting providers, as they're called? Section 1.4, paragraph 2, A2, of the asset purchase agreement states, if any of the providers do not execute and deliver an amendment and consent to assignment of his or her written employment agreement substantially in the form of Exhibit A non-consenting provider, then the seller shall reasonably cooperate with buyer, as buyer may reasonably request, in the effort to obtain for buyer the benefits of each such non-consenting provider's employment agreement with seller after closing, until such employment agreement's expiration. Such cooperation may include, without limitation, a professional services agreement between buyer and seller, pursuant to which seller will make professional services of such non-consenting provider under his or her employment agreement exclusively available to buyer, who will bill and collect, that's the buyer, for such professional services and compensate seller in an amount equal to seller's employment-related cost of such non-consenting providers. In other words, if they don't sign up with Franciscan, medical specialist and Franciscan agree to work together for Franciscan's benefit, not for the benefit of medical specialists in any way, shape, or form, to obtain the benefit of their services, even though they didn't sign their contracts. They know their contracts of all the doctors and medical specialists without assignment. Franciscan could not buy their contracts, they could not pay medical specialists for them, nor could they enforce any of the covenants contained therein. So they came up with a way to go around the black letter law and say, let's go ahead and find a way to take these benefits for ourselves, even though we're not entitled to them. And we didn't pay them, incidentally. So the May 22nd agreement takes paragraph 1.4A2 and puts it into action about 9 months after the sale. Whereas Section 1.4A2 of the Asset Purchase Agreement provides that if any of the providers, including the departing physicians, do not execute and deliver an amendment and consent to assignment of their written employment agreements, then medical specialists will reasonably cooperate with Franciscan, as Franciscan may reasonably request in an effort to obtain for Franciscan the benefits of each non-consenting provider's employment agreement with medical specialists after closing. That's part and parcel to the May 22nd agreement, which agreement permits medical specialists to compete in a limited capacity in what was formerly medical specialist non-compete area of 25 miles from its 45th Street and Calumet Avenue office in Munster, Indiana, for a period of 5 years. It said you can employ 5 full-time equivalent positions, and the effort is to defeat this lawsuit. Barb Green, president of Franciscan Health Munster, stated that very thing from that witness stand. That was one of the reasons they entered into the May 22nd agreement. I also submit, and I think we've made an effort to show that in court, and I think we have shown it through testimony, that the coincidental timing of the May 22nd agreement is no coincidence at all. The May 22nd agreement, which permits medical specialists to come up with some business interest that may require some protection, is entered into between the parties 2 days before their response to our motion for summary judgment is due, to defeat that motion itself. It's an attempt to do that. Of course, in that standard, everything the non-movement must say that's not wildly false must be taken as true, and I think it was. Let's go back to next slide. Let's take a look at what standard of review we're talking about. In this case, Mr. Jensen went through it briefly in the prongs. As stated under the law, we're correct. Under item 1, irreparable harm. In what instance, I can find none, would irreparable harm be caused by not entering the preliminary injunction in this case? Irreparable harm means something you can't go back and calculate. It doesn't mean it's not difficult. It doesn't mean it's not onerous to figure it out. It means it's impossible or virtually impossible to calculation. In this case, it's simple. If at some later point, for some reason that I'm not aware of, my clients are found to have violated the restrictive covenants, which we say are no force in effect for very good reason, then presumably every patient they have that they've obtained, whether they used to be medical specialists or whether they're new patients or from whencever they come. In other words, all the money they make, or calculated as medical specialists would have made under its building codes or its reimbursement, is easily calculable. That's these people's business. They do this day in and day out. They know exactly. And there was testimony regarding this. How much is made from each procedure, office visit, hospital round that's made on a patient. They know to the dollar, to the penny of what they're going to make. Not difficult to calculate, Judge. Item 2, the movement has at least a reasonable likelihood of success at trial by establishing a prima facie case. That is not true here. We have contracts that have been breached by medical specialists. Once that party, medical specialist, breaches the contract is void and they have no ability to enforce those covenants. Mr. Jensen and the defendants' movements here would have the court believe that there's a no defense provision in the contract where it says if the contract terminates, this provision survives. That's not the way it reads, and that's not how it's intended to read. And if it were, it would say so. When a contract is terminated because of another party's breach, that's not a termination, that's a breach. It's a different word and has a different meaning altogether. And we'll show a little later here, and we've shown through the testimony that those contracts were breached for multiple reasons as to each decision. That is a defending party here. Item 3, the threatened injury to the movement, that's medical specialists, outweighs the potential harm to the non-movement, resulting from the granting of the injunction. I submit to Your Honor that the movement, medical specialists, will suffer no damage and no harm because of these physicians practicing, because as we sit here today, they don't have one that's doing it. Not one. How could they be harmed? It's a good question and an easy one to answer. They can't. However, the 4 plaintiffs' non-movements here are enjoined preliminarily. They will suffer being out of business with no income. Their families will suffer. More importantly than all of that, their patients will suffer. Those patients number in the thousands. And I think at the end of the day, I hope we're all here, Franciscan and medical specialists and my clients, to put patient care and quality patient outcomes paramount to talking about and fighting over who gets what piece of the pie and how much money and how much goes around to whom. I think those issues are quite secondary. I think that also wraps up what we talked about item number 4, the public interest would not be disturbed. There was no evidence, not a scintilla, presented in the movement's case regarding the public interest. Other than a bald assertion when asked the question, I believe, would the public interest be disturbed? The answer was no. That's not evidence. That's a self-serving statement of no merit. We know there will be thousands of patients looking around and wondering where their doctors are. These aren't patients of a general practitioner or a family doctor that can maybe walk down the street and find somebody else. These are patients of specialist doctors. 2 pulmonologists whose patients and an allergist immunologist who by and large their patients are very ill from serious disease, and at the end of the day they can't breathe for the most part. Okay? I don't think those are the people you want looking around, wandering around, wondering when am I going to be able to get in? Does this doctor know my history? What am I to do? Dr. Leos testified as to a patient that took 2.5 years to come around and to tell him why he was having the sleep problems he was having. That's trust that's built up over a long period of time. You can't just replace that tomorrow. Doctors are not generic items that you pull off the shelf. Well, I think their case fails under the standard of review that's been stated and restated many times for the granting of preliminary injunction. Next one. Some good cases, quips regarding the standard of review, black letter law. The movement must prove each of these requirements to obtain a preliminary injunction. If the movement fails to prove even one, of these requirements, the trial court's grant of an injunction is an abuse of discretion. Any one of the four prongs fails to prove this court by a preponderance of the evidence. The motion must fail. The court's power to issue an injunction should be used sparingly, and such relief should not be granted except in rare instances in which the law and facts are clearly in the moving party's favor. I think, Your Honor, in this case we have anything but that standard having been met. It's not close. Mere injuries, however substantial in terms of money, time, and energy, necessarily expended in the absence of a stay are not enough. The possibility that adequate compensatory or other corrective relief will be available at a later date in the ordinary course of litigation weighs heavily against the claim of irreparable harm. And so it does here. We know these damages are calculable. A delay in requesting equitable relief is inconsistent with the claim of irreparable injury. Why do I bring that up? Your Honor can look at the timing here and see that my clients were openly, obviously, and conspicuously practicing medicine in their new offices as of July 1st, 2013. The motion for a preliminary injunction, in all of its few pages, was not filed until August 1st, 2013. A month had gone by. It might be difficult to claim the emergency and the need for preliminary injunctive relief, which is an extreme remedy, especially in this case, when you wait a month to even bother filing a motion. That, Your Honor, I think we've laid out the standard of review, and I think you've probably heard enough in that regard. Some quotes from Dr. Stemmer's testimony, including his on-the-stand testimony, deposition testimony. Dr. Atassi is violating his contract and competing with our doctors. So he is retaining all the work. He is retaining all the cash. That's what this case is about. Non-competes are disfavored by law and generally construed strictly against the employer. Non-competition covenants and employment contracts are in restraint of trade, generally disfavored by law, and will be construed strictly against the employer, also from the Kruger case. Okay. Kruger, Your Honor, you might want to a quick review of what that case was about. Central Indiana podiatry was just that, without any suffix. That wasn't an ink or a PC or anything else. The fellow who was basically a sole proprietor who had Central Indiana Podiatry one day changed it to Central Indiana Podiatry PC. Chose a different corporate form. Kruger jumps on that opportunity to say, that's not who I signed my deal with, it's PC, I don't know what this PC is. And the court said, that's garbage. All they did was change their name. And that's where the Kruger case comes from. But in speaking specifically about non-competition agreements with doctors, okay, that physician employment agreements deserve particularly careful scrutiny. Non-competition agreements are justified because they protect the investment and goodwill of the employer. In many businesses, the enforceability of a non-competition agreement affects only the interests of the employer and the employee. A non-competition agreement by a physician involves other considerations as well. Unlike customers of many businesses, patients typically come to the physician's office and have direct contact with the physician. If an agreement forces a physician to relocate outside the geographic area of the physician's practice, the patient's legitimate interest in selecting the physician of their choice is impaired. Moreover, the confidence of a patient in the physician is typically an important factor in the relationship that relocation would displace. In both respects, physicians are unlike employees in many businesses. The legal framework applicable to these relationships needs to take these differences into account. So the physician non-competes in employment agreements require an even higher level of scrutiny than in other cases not involving physicians, because patient care will suffer. Now I would like to talk about talking about having a legitimate business interest that needs to be protected. Medical specialists, I think we've said it enough until we're blue in the face. It simply has not. Certainly not in the clinical sense and not in any other sense. And in no sense between October 1st, 2012 and at least May 22nd, 2015. The reasonableness, the law will tell you, of a non-competition agreement is a question of law. In considering what is reasonable, the court must consider three factors. Whether the agreement is wider than necessary for the protection of the employer in some legitimate interest, the effect of the agreement upon the employee, and three, the effect of the agreement upon the public. We have in this case no legitimate protectable interest except the one that's been invented and, as Ms. Green testified, for the purpose of defeating this litigation. We are the filers of the declaratory judgment action, if the court will recall. What we didn't want to do, and the reason that we stayed in the medical specialist's office performing services, was not to harm the public. And it says that, and that's specifically the patients, and it says that in Plaintiff's Exhibit 4, the letter which some of the language was taken out, but not all, and put before the court. We wanted to come to this court with clean hands, without having abandoned our patients. We frankly didn't know what our patients would do had we not stayed. Now, it seems medical specialists would want to argue that we'd be in a better position had we just taken a pass October 1st when we opened our office down the street. That wouldn't be fair to the patients. Wouldn't be fair to the employees that we're still there and still working and need someone to work for. In arguing the reasonableness of a non-competition agreement, the employer must first show that it has a legitimate interest to be protected by the agreement. The employer also bears the burden of establishing that the agreement is reasonable in scope, time, activity, and geographic area restricted. Remember, in this case, we've heard about a 10-mile radius non-compete. That 10-mile radius, and you'll see, Your Honor, in the attachments to our motion for summary judgment, is from every medical building and hospital that my clients ever stepped foot in during the term of their agreement. I think Dr. Atasi's may be the most extreme example. Dr. Atasi's worked in every hospital from here to LaPorte. His 10-mile radius, or 10-mile bubbles all the way across the northern half of the state of Indiana. And the same is true not to that great of an extent, but for the other doctors as well. They've all worked in multiple locations. Maybe that's part of the design, maybe that's where the work was. But in any event, it's not just 10 miles from one spot. It's 10 miles all over the Northwest region. And that evidence is in the record as an attachment for our motion for summary judgment. Indiana law prohibits a medical practice from claiming a protectable business interest in the patients of another entity. Even in the commercial context, Indiana law prohibits employers from claiming a protectable interest in its past customers. They can't, a medical practice, in other words, for one other way to put it, they don't own people. They don't own a patient. They can own a patient file, patient diagnoses, things along those lines that maybe they're privileged, maybe they're not. Many of them are available electronically on the ethics system mandated by the U.S. government. But to the extent that they can own a person as a patient, they cannot, and have no protectable interest in that person or customer, or past customer. Okay, I already addressed that. When keeping in mind, Your Honor, what we have here is an asset purchase. I do want to remind the court of some statements from Dr. Stemmer's testimony, which I think were very telling. Dr. Stemmer did state in his cross-examination that he argued with Franciscan, to one extent or another, to do this as a stock purchase. In other words, if Franciscan would have simply bought the stock of medical specialists from all of its shareholders and operated it as medical specialists, although the boss may be someone different, the money may end up somewhere else, but it would have to run through medical specialists one way or another. The incidence of employment wouldn't have changed. The name would even be the same. They could even change the name. But they didn't do that. Dr. Stemmer wanted them to do that, but Franciscan said, no, we do asset purchases. We don't buy the stock. I think we all know there are reasons for that. If you buy the stock, as opposed to the assets, you also buy the liabilities that come along with it. There could be things hiding out there. There could be cases, debts, and obligations that haven't accrued yet, or that the buyer may not know about. So a lot of buyers want to be clean, wipe their hands. I bought your assets. You keep your stock, your liabilities belong to you. I'm only buying the white meat. I just want the good stuff. Okay? Because they chose that, and because medical specialists went along with it, I think they should have to live with the consequences thereof. Because that was the bargain they made. When companies merge in a stock purchase, the surviving corporation generally succeeds to the employment contracts of the merged corporation, including any non-compete clauses contained within those contracts. Just what we just talked about. The surviving company also succeeds to all of the merged corporation's liabilities. That's the bad stuff that they didn't want. When a company is acquired through an asset purchase agreement, the acquired company's employment contracts cannot be assigned to the purchaser without the employee's consent. That's the L versus Durima. The purchasing company similarly cannot enforce the acquired company's employee non-competes without the employee's consent. Knowing that that's black letter law, that's why paragraph 1.4A2 was invented. We know we can't take them. We know we can't buy them unless they agree to have their contracts purchased or assigned to us. So let's find another way between Franciscan and medical specialists to give all the benefit of those agreements to Franciscan, even though they didn't buy them. And Your Honor, to further, I think, illuminate that point, let's go, Jonathan, to Barbara Green's testimony, please. Barbara Green testified in this court that they made a deal, they made a bargain. She was one of the key negotiators. If Franciscan could get 48 medical specialist physicians to assign their contracts to Franciscan, then Franciscan would still get the value that had been placed on the practice. They bargained for 48 assignments. They put a sharp pencil to it, you might imagine. Said if we can get 48, we've got a deal for about $21 million. No quarrel that they got to 48. No quarrel that that was the value they placed on it, $21 million. They got exactly the benefit of the bargain that they made. Franciscan Alliance cannot enforce the restrictive covenants in the non-consenting physicians' employment contracts. That we know, that Ms. Green admitted on the witness stand. Dr. Stemmer was allowed to recruit physicians into medical specialists, even though he worked for Franciscan medical specialists as a recruiter, because it would help protect the goodwill that Franciscan had purchased. In other words, Dr. Stemmer could have just recruited replacement doctors into Franciscan, because that's his job, one of his jobs with Franciscan. Not only is he the president of Franciscan medical specialists, he's also the president of medical specialists. So apparently he can go from one side of the desk with one hat on to the other side of the desk with another hat on and say, I'm doing this for Franciscan and I'm doing this for medical specialists. I submit to Your Honor that that is not true. I submit to Your Honor that the benefit of these agreements are all meant to run to Franciscan or Franciscan medical specialists or another one of the controlled entities of Franciscan Alliance. Additionally, Your Honor, from Ms. Green's testimony, as to the May 22nd agreement, Ms. Green stated that one of the purposes of the agreement was to defeat this lawsuit. In other words, Franciscan and medical specialists have, well after the fact, colluded to obtain for Franciscan what Franciscan cannot lawfully obtain for itself, pursuant to the asset purchase agreement. Ms. Green had already stated unequivocally that Franciscan already paid for and received the benefit of their bargain, the services of the 48 physicians that agreed to assign their contracts to Franciscan. This, Your Honor, is really it's the cherry on top of the cake, I guess. We got what we bargained for. We paid $21 million for it. Let's get more. They want the non-consenting physicians' practices to be taken from them and usurped by someone else. I think Mr. Jensen, Your Honor, in his argument stated that MedSpec deserves this protection because they built up this practice over a number of years. All the founding members did a lot of work and they built this up, and they deserve to protect it because they've got something to protect. I submit to Your Honor that they did build it up, and that they sold it for $21 million, that they are free to distribute amongst themselves as their agreements provide. What they built, they sold, and were paid handsomely for it, and that's wonderful. Very happy for them. But to do this to these physicians, to these patients, I hate to use the word greed because it has terrible connotations, but I don't have another one. That's what this is. Get it all. Don't just get what we bargained for, get more. Your Honor, I think in this instance, a preliminary injunction should not issue for all the reasons that we just stated. In addition, it's sometimes difficult to find a case, very, very, very close case that we have here in the jurisdiction that we're in. But what I'd like to point the court to for perhaps some guidance, although not fully authoritative, may be persuasive to the court. A material breach precludes medical specialists from enforcing the employment agreements and restrictive covenants. We know that was from Kruger. We've got a medical practice's failure to provide timely and competent billing and collection services constituted a breach of its agreements with the physician, such that that practice could not enforce the non-competition provisions in the agreements. That is Roeder versus Farrell Duncan Clinic, Inc., 155 Southwest 3rd, 76, Missouri Court of Appeals 04. Medical practice's attempted assignment of a physician's employment agreement without the physician's consent invalidates the covenant not to compete. The asset sale, in and of itself, is a material breach. We're talking about material breach. What material breaches do we have? For one, the fact that the asset sale itself is a material breach of the agreement. All the assets of the company, which they had employment agreements with, were gone. Every computer they touched, every billing code they put in, every piece of equipment they used, every test they performed was using Franciscan's equipment. And Franciscan, at least from October 1st of 2012 through the end of December of 2012, billed and collected for their services. They didn't even work for Franciscan. But they were being treated as though they did. They even got offered health insurance plans that said they had to sign, and those plans said that they were employees of Franciscan medical specialists. They weren't. So they went out and they bought their own health care plans. Another material breach of the agreement. In Strodman versus Integrity Builders, 668 Northeast 2nd, 279, the Indiana Court of Appeals states that a party breaches a contract either by placing itself in a position where it is unable to perform its contractual obligations or by failing to perform all of its contractual obligations. That's exactly what medical specialists did here, by selling all of its assets. And by having some other company, through some art of this, offer health insurance, which my clients weren't even entitled because they didn't work there. Similarly, by agreeing to make the plaintiff's professional services exclusively available to Franciscan, medical specialist demands from the plaintiff something to which he has no right. This is a repudiation and a breach. Citing Eden United Inc. versus Short, 573 Northeast 2nd, 920, Court of Appeals 91. Demanding performance to which the party has no right under the contract constitutes a repudiation and anticipatory breach. Given all that's happened here, and given the testimony and the evidence on the record here, the movements have not met their burden in order to establish that a preliminary injunction should issue. We submit to the court the preliminary injunction should not issue. We have today, along with the movement, submitted findings of fact and conclusions of law and form of judgment for the court. We know we've also, I believe on Monday this week, submitted or Tuesday this week, submitted designated material from certain of the depositions. I know the court has a lot to do. The court has been very flexible with this time. We appreciate the opportunity. Thank you.
Thank you. Jesse?
There are 21 categories of excluded assets in the asset purchase agreement which were not purchased by the Franciscan Alliance. Those all continue to be assets of medical specialists. There continue to be physician employees of medical specialists, not the least of which are the 4 plaintiffs to this litigation. 4 plaintiffs who insisted as a precondition of remaining in place that they be regarded as employees of medical specialists. This is not a situation in which there has been any material breach by medical specialists, and these plaintiffs insisted that medical specialists continue to employ them. Their own employment agreements provide that there are health benefits to be furnished to them, but it doesn't say from whom or under what circumstances. They decided that they didn't want health benefits that were offered to them, but health benefits were offered to them. They continued to go to work at the same location. They continued to make use of the same equipment, by the way, which wasn't owned by medical specialists, but by FCCI. They continued to have access to the patient's charts. They continued to have schedules prepared for them. They continued to go to the hospital. They continued to receive their paychecks. And they continued to demand that they be paid as unit holders under and pursuant to Schedule F or Exhibit F of their employment agreement. Conspicuous from counsel's presentation is any reference to their non-violation of the covenants not to compete. It's as if it didn't happen. Their whole argument is you can't enforce the covenants because the business entity changed before and after October 1st. But there is no case that holds that the change in the entity, while the entity continues to function, somehow or another makes it unlikely that the entity can enforce the agreement, which the plaintiffs demand be enforced. The fact that medical specialists changed after October 1st finds no support in the cases that it is somehow or another precluded or foreclosed from enforcing its contract. There is no case with regard to that. And if the plaintiff said the contract is breached, we're not going to work for you. We regard ourselves as relieved of our obligations under the contract. Why do they insist that we remain employed by medical specialists to continue to get the benefits of the contract? You can't have it both ways. we can talk all we want about Central Indiana podiatry, but the simple fact of the matter is Dr. Kruger lost. Why did he lose? Because he couldn't take advantage of a change in his employer to his own benefit. Why should these plaintiffs be able to make the same sort of, and take the same sort of advantage with a change in the number of employed physicians while they remain employed? Why should they be able to take advantage of that when Dr. Kruger could? And why should medical specialists be in a position that it has to walk away from the enforcement of these covenants, which we know it has a right to enforce? Now, we're told repeatedly that if you have a breach, you have no rights. But the simple fact of the matter is that our contracts provide that regardless of the reasons for the termination, the covenants survive. And as the court tells us in Central Indiana podiatry, to the extent we find any authority on no defense provisions, the provisions have been upheld, even in the face of apparently major breaches by the employer. Now, with regard to the contracts, if medical specialists doesn't exist, why is it that a third party, no friend of the Franciscan Alliance, enters into contracts with medical specialists? And they have done it repeatedly after January 1st, 2013. Isn't one of the hallmarks of a corporate existence the ability to affect your legal relationships by entering into contracts? And who enters into contracts? All of the entities in the community firmament after January 1st, knowing full well about what has taken place. After January 1st, they enter into contracts at St. Catherine's, they enter contracts at St. Mary's, and they enter into contracts at Community Hospital. And these contracts are not, as counsel says, simply for the provision of administrative services, although administrative services would be important. Exhibit A to contract, which is number E, which is, for instance, the co-medical director, a ship agreement, dated April 1st, 2013, well after the commencement of this lawsuit, between Medical Specialists Inc. PC and St. Mary's Medical Center, specifically provides in Exhibit A, which is page 16 of the contract, quote, furnishing such consultation to the members of the medical staff of hospital as may be required by the hospital. That's the clinical practice of medicine. The same obligation is included in another contract, which is Exhibit F. Wound care, job description. Exhibit A, serves as consultant to attending physicians when requested. That is the clinical services that a physician has to provide. And what did Dr. Stemmer testify to? What did Barb Green testify to? They recognized that the non-Franciscan Alliance affiliated hospitals were not going to have these type of kinds of administrative contracts where policy was being developed, where procedures were being developed, operated, and discharged by people who were employees of the Franciscan Alliance. So they were going to enter into contracts with medical specialists, and medical specialists had to fulfill those contracts with individuals who, when they were providing those services, were non-Franciscan Alliance physicians. That's the steps that are being taken in order to fulfill this. And the fact that the parties recognized that this was something that had to be done, and they had to fulfill all of these contracts that were entered into after January 1st of 2013, and they entered into an agreement on May 22nd, 2013, doesn't for a minute make any difference with regard to the fact that the community hospital system expects non-FA employed physicians provided by medical specialists, not Franciscan medical specialists, to provide those services. The thought that a company because it changes, can't enforce its contracts with individuals is simply wrong. There is no basis to reach that conclusion. Now, was medical specialists in existence after October 1st, 2012? Yes. Does medical specialists continue to employ physicians? It employed the plaintiffs until June 30th. Does medical specialists have the right to employ replacement physicians? The answer to that is indisputably correct. Has medical specialists entered into employment arrangements with physicians to replace them? Yes, it has. The June 6th date for Dr. Chi is the date of the contract. Dr. Chi begins her practice on October 1st. Medical specialists entered into letters of intent with 7 or 8 physicians in order to fulfill their obligations to take care of patients and to meet their obligations to the community hospital. And medical specialists even offered continued employment by it, not by Franciscan medical specialists, to Dr. Akasi, one of the plaintiffs in this case, in June of 2013, while he still was employed by medical specialists. The notion that you can say that I don't think you exist anymore, even though you're different, but continue to affect your legal relationships with contracts, continue to affect your legal relationships with entering into employment agreements, continue to continue to pay the plaintiffs, continue to have an obligation to the plaintiffs to actually redeem their BB unit holders pursuant to Exhibit F to each of their contracts to the extent that they are a B unit holder, defies credibility. They get the benefit, but they have no corresponding duty. Now, I don't for a moment say that this is the easiest case in the world, but there certainly is no doubt that the covenants have been breached. There's certainly no doubt under existing case law that we can't quantify our damages, and as a competitive injury, we're entitled to be able to get an injunction. There's no doubt about the fact that the public interest is the interest of entering into a contract. And that's been decided since 1983 by the Raimundo case. And the balance of the hardships, we're entitled to protect the interest that we have in having developed and nurtured these physicians, because we continue to be an entity that has to make services available to the non-Franciscan Alliance hospitals. And we have to do that through non-Franciscan Alliance employees. And those employees are going to be Dr. Smith, Dr. Stokar, Dr. Dumont, and we already have an employment agreement with regard to Dr. Chi. So we have the right to replace doctors, we have the right to enter into contracts, and we have definitely entered into contracts in this case. Nobody would say that we don't exist, and to have a third party like community hospitals say you don't exist would be a very, very strange thing indeed, because they've entered into 6 contracts with medical specialists, which they expect medical specialists to fulfill with non-Franciscan Alliance employed physicians. The fact that things have changed over time, and there's a recognition, as Barb Green testified to, with regard to the resistance that has gone on to Franciscan Alliance employed physicians providing services at non-FA hospitals, is only a frank recognition that we want to continue to be able to supply that physician. As she testified, we underestimated the reaction of our competing health facilities. When Methodist terminated Dr. Reaver's contract, and when some issues with community came up, we decided that we should leave some contracts in place instead of assuming them as we had planned. And remember, these contracts were never assumed. Ms. Green testified to that. Dr. Stemmer testified to that. Schedule 1.C in the contract, in the asset sales agreement, lists scores of contracts, including the employment contracts of these plaintiffs, which we know absolutely were never assumed because they weren't assigned. And as counsel has already told you the contracts with the non-Franciscan Alliance hospitals, the community hospital system, they weren't assumed because they weren't assigned. So there had to be another way to provide that service. And that's exactly what's going on here. To say that they're listed is to say only part of the story. The simple fact of the matter is they were never assumed because the contractor would never agree to it. But the contractor has made clear since October 1st, 2012, is that we want to do business with medical specialists. We do not want to do business with Franciscan Alliance. And we expect medical specialists to fulfill those obligations as an ongoing entity. That's all that's important for purposes of this proceeding. Are we an ongoing entity entitled to legal protection and enforcement of our contract? A contract that the plaintiffs wanted continued, a contract that the plaintiffs benefited from, and a contract that they intend to be enforced as holders of units of ownership. The answer to that is absolutely yes. This preliminary injunction should be entered. People who sign covenants not to compete should not at the 11th hour be able to wiggle away from it. And to not enforce these would be to run against all of that authority that's before you. In fact, I can't find a case that's been cited by the other side that says you can't enforce these agreements. The simple fact of the matter is, even though sometimes a trial court want to do it, the simple fact of the matter is that the courts of appeals and the Supreme Court have enforced these contracts multiple times. Thank you.
But as you all stated, I do have quite a bit here. How soon do we want something on this? I would have said I don't think I can get this done before 30 days.
We waived the rule you're at.
Yes, sir.
Okay. I would think I would have it within 30 days, but not much. If I go beyond the 30, it won't be by much.
Yes, sir.
Okay? And we have all your findings and conclusions submitted?
If I copy with the disc, I'll still have.
Okay. All right. Anything else, Randy?
That's all I can.
All right. Thank you. All rise.